to address issues such as domestic and foreign taxation of income producing structure, international families and child guardianship planning, domestic taxation, estate, and gift of non-resident alien U.S. domestic assets. Likewise, shall we enjoy traveling around the globe and tasting great food out there? Welcome, shall we?
Thanks, Donley. Hi, everyone.
Okay, so before their presentation starts, I'd like to quickly introduce two smart rules about questions. So for everyone's best seminar experience, if you have questions during the presentation, please remain mute and type your questions in the chat box. We have volunteers to collect them. And then alternatively, you can also save your questions to the Q&A section at the end. And then without further ado, everyone, please welcome Tax and Complex Estate Attorney Michael Lee and International Estate Planning Attorney Xiaowei Li. Michael and Xiaowei, the time is yours now, please.
Great, thank you. Before we start, let me just confirm, should I present in English or Chinese? Before I was instructed to present in Chinese, but I saw many names. It seems like I should present in English.
In this case, English, please.
Okay, great. Yeah, just want to double check on that. Okay, let me share my screen.
And don't worry, it will be in English from me. So I've only got English.
All right, great.
All right. Okay, can everyone see my screen?
Yes.
Great. Michael, do you want to start?
Well, great. Thank you so much. And it's great to be welcomed by CASPA. We're really excited to be with you on this very nice Sunday, or pardon me, Saturday. We have great weather, though of course we're all indoors. So why are we so excited to be with you and think it's such a good match is just like the founding and the background of persons in CASPA. CASPA is a highly international technology professional organization. And with your unique attributes as CASPA members, you will find as we go through our slides today and talk that your estate planning, your planning for your US taxation and your estate affairs is going to be slightly different and in some ways more complicated than, let's say, you're just a US domestic person. So as we'll see, Xiaowei will kick us off here and get started, and we will start to go through and find that there are some uniquenesses and differences.
Yes, so our law firm, we specialize in complex and international estate planning. So we actually, we work with many professionals, such as financial advisors, insurance agents, real estate professionals. We also work with a lot of clients. So we have extensive experience in advising clients in this particular area, and this is the only thing we do. We actually also receive a lot of referrals from other attorneys, many immigration attorneys or business attorneys. They receive their complex and international estate planning cases to us. You know, this is what we do, and we enjoy doing that. So hopefully today, during the seminar, we can bring our knowledge and experience to all the attendees, and you can learn something with us. I think Donglei already introduced us, so we can just go into the probate section. So for today's seminar, so at first we'll discuss this broad concept of estate planning. So why everyone in California needs estate planning, why you need a will, trust, power of attorney, and advanced healthcare directive. Then we'll move on to estate tax planning. So for people who have more assets, who have assets over $5 million or $10 million, you need something more than some basic estate planning. We'll discuss discuss about that later. And then Michael will move on and talk about more advanced planning about capital gain tax or some advanced tax planning techniques specifically for technology professionals. So why in California, for average person, you need to consider estate planning? Can I ask this question to Donglei? What's your understanding? Why everyone in California need a estate plan?
Well, from my personal aspect, definitely like I'm right now in the middle of a career transition, and then I know that there will be a lot of different packages coming in, and then there will be like incentive stocks and then things like that, right? So these things I don't really know how to navigate through. So I'm really looking forward to your presentation. Give me some insights.
Great, great. Yes, so basically in California, if you have assets over $166,000, you need to do a basic estate plan. Otherwise, you have to go through this process called probate. Actually, Michael and I, we just talked about it right before this seminar, you know, how slow the St. Clara court process is. So the probate is a court process. If you do not do any estate planning, and if you lost the capacity, or if you pass away, then your property has to go to this court process called probate. And in probate, the court and the probate judge will decide how to divide your assets and how to give your assets to the beneficiaries. And probate is a public process, is very lengthy. It can, in St. Clara County, for example, it can be over 18 months. And also the most important thing is costly. It's also very expensive. So for example, for a $1 million worth of assets, the probate fee is around $30,000. It's a percentage of your overall assets. Also, your mortgage is included, so your mortgage won't be deducted from your total assets. So, you know, to save your money, to save your time, and the most important thing is to have a streamlined distribution and avoid probate process. And a basic estate planning is needed for everyone who has over $166,000 and lives in California. As you can see in Bay Area, if you own a house, no matter where it is, your asset will exceed $166,000. So estate planning is very, very important and essential for everyone. Michael, do you have?
Yes, actually, and I think this is something that's very interesting. We have clients from all over the world, of course, China, Germany, many legal traditions that we call civil law legal traditions. And if you could just go back to the last slide, Shui. And a lot of people look at this and say, oh, you know, in my home country, this is very easy. I have many clients from Germany and they say, oh, I just go down to my basically Lander state office and I just tell them what I want. And they just write down what I want and put it in my file. And if anything happens, my family goes there and they pull it out and we're done. And it's very, very simple. And unfortunately, in California, that is not the process that we have. If you do nothing, we use a process that looks very similar to what they used in England in the 1400s. We say, Mike Lee, Lord of the Manor, has died. All persons with wills come forward and present your claim. And then the judge will say, that will is the true will, and you are the true son. And then that's the person who takes. And we can have all kinds of fun where we fight about forged wills. And California is very fun, is we all children take equally. So someone, as you see in the celebrity cases, someone comes forward and says, I'm Mike Lee's son. And my wife and other kids say, I don't know that person. And they say, oh, but I get a third. We get to have all that fun. Lawyers call that fun. Clients call that costs. And I quote this case because it's one of my favorite cases. If you ever went to Los Angeles and went to the Getty Center Museum and thought, gosh, this is just a pile of masterpieces in here. Who paid for all of this? It's the Getty estate that eventually became Chevron. And the reason I quote the case here from 1983, like Xiaowei mentioned, probate fees are set by law and it's a percentage of the estate. Of course, the Getty estate was massive. He just had wills. In 1983, the probate fee for that estate was $18,500,000. As of today, if you did present value calculation, the attorney's fees for the estate was $52 million. So you can imagine, again, and like Dong Lei mentioned, CASPA members often have larger estates, complicated estates. This number can go up very fast. So we want to get away from probate, and Xiaowei is going to tell you how we do that.
Great. Great. So usually what we do when clients come in, they present us a situation. Usually we will draft basically 4 documents for a client, a will, a trust, a power of attorney, and also an advanced healthcare directive. And the major document is called a trust. And you basically put all your assets into your trust, your revocable living trust. The trust is usually revocable. We'll talk about irrevocable trust in a little bit, but in a basic estate planning, the trust is usually revocable, which means you can change your trust, amend your trust at any time. You can even cancel your trust. And a will nowadays basically is just a supportive document for the trust, and you would instruct the court if something happened to me and if my property is not in the trust, I forgot to put into my trust, then my properties will go into the trust. Also in the will, and this part I'd like to talk more. And in my practice, I encounter a lot of situations require a lot of counseling for guardianship situations. I believe a lot of CASPA members have children, have minor children. But whenever you have minor children in your estate planning, a question you need to think about, usually is in the will, is you need to appoint your child's guardian if something happened to you. So for international families, the situation is a little bit complicated. If all your family members are in the US, it's relatively easier. Usually you can appoint your siblings, your parents, your best friends. But for a lot of international families, you do not have somebody you trust in the US. For example, your parents may not have green card or US citizenship. Your sibling may not reside in the US. Your best friend may not in the US. Then how do you plan for the guardianship of your minor children? Usually, I would advise clients to think about who their children usually play with. Probably for a temporary guardian, the family you usually play with, the parents are good candidates for in this kind of situation. And then you can give the permanent guardianship to somebody who you trust abroad. For example, in mainland China, in Hong Kong, or in any other places. But in other situations, when you can always talk to us, you can always discuss with us your family dynamics, your family situation, and with our experience and knowledge, we can present a solution for you. I think that's the key thing about estate planning, and Michael can add something if he wants. I feel like a lot of people think this is more like a drafting a document, but for us as very experienced estate planning attorney, the consultation is actually the advice are more valuable than the paper, the documents themselves. Because when client present a situation to us, they may not think, they may know their family really well, but then they may not have the experience or knowledge to deal with the situation. So for example, I can give you an example which is very common among Chinese families. So some of my clients, they really don't want give their children their money all at once. So they like to set up very strict restrictions. For example, if my kid cannot go to college, then I may not give my kid the funds. But the question is always, if you only have one kid, and if your strict standard is the kid has to go to the college, then if the kid didn't go to the college, then what do you do with your estate? A lot of people just think part one of the question, but didn't really think it through. So in this process, we'll advise client, the choices, and you have many other ways you can restrict your children from access to the funds, because when they are young, especially when they are freshmen in the college, or even at their early 20s, you probably don't want to give them too much from your estate, because you never know, because in college anything can happen. They may have a car accident, they may have creditors, later on their marriage may have some problem. So when you plan for your estate, you need to think about these problems, and each family present a unique scenario, unique situation to us, and with our experience we can provide the best consultation to our clients.
If I could just go back to the guardianship issue, I think this is really critical and something that I see often in my practice that can be a real big problem. Here's the problem, and this is very common throughout Silicon Valley because we are an international valley. We have people from all over the world, and this is the problem. Let's say my wife and I, we may be citizens, we may be permanent residents, but we were citizens of another country before. Let's say China. Very, very common. So we were citizens of China. Very commonly, we come here, we meet, we go to school, we marry, we have children here. My child becomes a US citizen. But oftentimes, we may be the only two here, my husband and wife. And of course, for my child guardian, if something happened to my wife and I, often we'd say, well, my wife's mother would be the best guardian, or my wife's father, or my parents. But they are non-citizens, non-residents, and guardians are appointed by the court. And just think about how this problem comes about. You have a US citizen child, and then there's a question of who's going to be the guardian, and you say, oh, a person from PRC China who may want to take them back to PRC China. Unless you have some writing and some this procedure thought through, do you think Judge MD or Judge Bransert are going to send this US citizen minor to PRC China? Unless you explain in your documents and say, no, I have a close relationship with my parents, and my husband agrees, or my wife agrees, and we together agree that that's where they should go. And we know that they're not a US citizen person who will be the guardian, and we understand that, and we consent to that. I think Judge Bransert will feel more comfortable, because when he gets a guardian petition, doesn't know, do you have a close relationship with the parents, or are you fleeing a communist country because of your political views? I don't know if I'm the judge. And if I'm a US judge, I would say, I'm going to err on the side of California law. They're staying here. I'm not going to send them anywhere. You need to explain this. And while you're explaining this, like Xiaowei mentioned, you should probably have a backup. A lot of estate planning is belts and suspenders, temporary guardian. In that gap period, we say there's going to be a seamless transition if anything should happen. We're going to have the temporary guardian, US citizen or US permanent resident, local, 10 minutes away. Anything happens, boom, this person takes care of it. And then I've specifically explained why I want my mother-in-law or why we want my father. And I'm aware that they're a non-US person, and that's the best interest of the child. That's the key word, best interest of the child. You better explain that, because otherwise it's going to be Judge MD guessing. And that's not good planning. So that's the thing for guardianships, because again, all the money in the world, I think, again, when I think of, my family, I care about the properties and all of those things. I care about my kids way more. That's what this is all about.
Yes, the key words, as Michael mentioned, is the best interest of the child. So all the documents, you need to demonstrate that your arrangement is in the best interest of your child. That will be extremely helpful if something happened and the court needs to make a decision who will be the guardian of the child. Okay. So we just, because of we have limited time, so let's just move on to the next step. And I know many CASPA members, they are high net worth individuals, or they other than the basic estate planning, which you probably already have or heard somewhere, another very important part is to do estate tax planning. So last year there are a lot of changes, a lot of proposed changes, which did not eventually go through. You probably heard the current estate tax exemption is $12 million for US citizens and US green card holders. And last year in October, there was a proposal, the estate tax exemption will be lowered to $6 million, $5 to $6 million by the end of 2021. But that law did not pass. So in 2022, we still have $12 million for green card holders and US citizens. But what you need to understand is this number is not permanent. So it will be $6 million by December 31st, 2025. So if you have $10 million as an individual, or if you have more than, if you have $5 million to $6 million as an individual, or if you have more than $10 million as a couple, you need to keep this in mind. You need to think about it. What can you do in the next 3 years? And in the US, the estate tax and the gift tax, they use the same scheme, which means if during your lifetime, if you maximize your gift tax exemption, then when you pass away, you will not have any estate tax exemption. Michael, if you want to elaborate, you can elaborate on this part. Otherwise, yes. I'll move on to the next slide.
Let me just say a couple of words. What we're going to get into, we want to be a little bit brief and general. And the reason why is because this is, unfortunately, mind-numbingly complicated. And I'm telling all of you as CASPA engineers who are brilliant people, trust me, if you spend some time with this, you'll say, wow, this is crazy complicated. When I teach this at Santa Clara School of Law, it's a semester-long course. So we're going to just broad brush it. Easy way to think about it. In the United States, federally, there is a death tax. When one passes away, there's an amount that one could potentially owe. What's it all about? What do we always think about for this death tax? Well, what's exempt? What's the number excluded? Basically, it's the bar. If I'm under the bar, I don't care. If I'm over the bar, I'm going to hit the bar, I care. Problem is, the bar is going to move. Right now, the bar is super high, $12,060,000. I say, perfect. I have less than $12,060,000. That's my plan, Mike. I'm going to go with that. Say, not a good plan. They say, why not? Well, your plan relies on you dying before December 31st, 2025. That's not a good plan. I better have a different plan. We need to plan to live. So this is the thing. If you ever look in your rear view mirror or on the car, the side mirrors, it says objects in mirror are closer than they appear. That needs to be on the estate tax. Estate tax exemption is lower than it appears. Be thinking about $6 million. That's the reality of what we're going to be dealing with.
Great. Okay, so just to emphasize this, $6 million, or you heard about like $12 million. There are two elements I found that people are frequently confused. One is, as Michael just mentioned, is the federal death tax, is a federal estate tax exemption. So in California, oddly enough, in California, we don't really have state estate tax. I actually consult some clients from Washington State, like Seattle area, and Washington State has their state estate tax, which is $2 million. And it's over $2 million the state wants to tax you for your estate. But in California, lucky us, we do not have the state estate tax yet. So the only thing you need to think about is the federal estate tax. But then there's also this very important element of the citizenship or your status. And how do you qualify to have this $12 million exemption in 2022? Or 6 million exemption after 2025 is you have to be a green card holder or a US citizen. If you are not a green card holder or you are not a US citizen, then you do not have this exemption. Your exemption is only $60,000. So over the years, we have counseled many individuals from abroad, and they just come to the US to invest. For example, they want to purchase US real estate because they think it is a good investment. Or if they just want to come here to set up a company to do business, but then they do not want to obtain the US status, which means they do not want to become US permanent resident, or they do not want to become US citizen, then you need to keep in mind, your exemption is not $12 million, not $6 million. Your exemption is only $60,000. And anything over $60,000, the estate tax rate or gift tax rate is 40%, which is very, very high. So before, just want to remind everyone here, I think most of CASPA members probably already have the US status, but if you have family members, they do not have the US status, but they want to invest in the US, they want to just do some business adventure in the US, then before they set up their business venture or their investment, they need to talk to a estate planning attorney to set up the structure first. Otherwise, once you already put your money into the US, it will be very, very difficult for us as estate planning attorneys to do anything for you because there's always this gift tax issue.
And this is also essential for CASPA members because I see it a lot with Silicon Valley professionals, especially technology professionals. Status is somewhat changeable, particularly if you are in the permanent resident status. And this is where I see a lot of clients, and we counsel a lot of clients where we could have a big problem, is working here, everything's going well, happy. And then all of a sudden I get an offer I can't refuse from Singapore. And I say, I'm going to Singapore. This is really, really attractive. And I leave the US. And let's say I owned a house or something like that. I was a permanent resident. I'm in Singapore, time is passing. I go out of status in the permanent residency. I lose the green card. I just become a non-resident, non-citizen. That house that I have that was protected by the exemption, the 6 to 12 million, it's now 60,000. Wow, I should have planned before I did that, because before I left, I could have done some clever planning and boxed up the house and put a bow on it and said, no problem. But if I just say, it's probably fine, I'll figure it out later, you could have a massive problem. So that's one thing that is critical with the residency, is it's not necessarily something that is immutable. It can change, and especially with countries like PRC China, Republic of Korea, India, they are not joint citizen countries. So I have a lot of clients that are European, Canadian, and you can just collect the passports. You say, I have American, Canadian, Singaporean, Australia, doesn't matter. They let me have as many as I want. But that does not work. China, India, Korea, you can just have one. And there can be some problems if you decide to change or switch back. That makes the estate tax planning very complicated. One last thing to mention that we have to be careful with permanent residents. One thing very critical that you should all know, if you are a couple and one of you is a permanent resident, the marital deduction between spouses, this basically situation where if I'm married and my spouse passes and I receive the assets, I don't pay any estate tax, I don't really have to do very much. That does not work for you. So this is a key thing, and why I'm so eager to be with the CASPA members. If you are a permanent resident or on a visa, your basic estate planning works slightly differently than a US citizen couple. So again, the planning needs to be tailored for what you actually have. The generic off the rack thing is likely, as we'll see in a chart here, do the exact opposite of what you're supposed to do.
Yes, so recent years we did see many people they decide to leave the U.S. Especially if their company will go public overseas and they do not want the U.S. status because they do not want to become a tax resident in the U.S. And then Michael just mentioned that you just need to do a lot of planning before you give up your U.S. status. I just want to add this, which is very, very common in the past 5 years. Okay, I
And
think
these are just
yeah.
just 3 quick warnings that we mentioned that we
Sure.
This especially applicable to CASPA persons. One is that we mentioned, again, the objects in mirror are closer than they appear. The exemption is lower than it appears. It's going to drop down 2025. Second thing, marital deduction for non-US citizens, i.e. green card holders, works differently. You need to have your trust tailored for that. And then if you're a non-citizen, non-resident, be very careful. It is $60,000. We had a terrible case about a year and a half ago. Family was from Taiwan. They aggregated all of the assets in Taiwan. They brought them here and they bought 2 beautiful houses down in Beverly Hills, in the Hollywood Hills there. For some reason, they titled them in the name of grandma, and then she promptly passed when she arrived here. They lost 40%. The sort of family wealth that they had been accumulating for years. IRS said, whoop, win for Uncle Sam. Thank you, Taiwanese family. Massive, crazy, illogical planning that they did. And it was heartbreaking. I mean, it was heartbreaking to say you owe $4 million in taxes. They say that's 40% of the family wealth. Say, it's owed. They say, well, can we take it out? You bought real estate. The IRS has liened it. They're getting their money. So again, that example, just very clever, thorough, but not crazily complicated planning would have saved them tremendous amounts of money. This is just a quick chart here. What you're supposed to do, looking at on your screen, the right-hand side of this. We're not going to go through it because, again, crazy complicated. But again, the situation is as you can see, marital trust versus family trust. Generally, sophisticated trusts should break into subtrusts. This is sort of the ABC trust. U.S. citizens, generally the trust will lean towards and fund this one here called the marital trust. If you are a permanent resident, you should do the exact opposite and potentially fund the family trust first. So again, if you go with sort of standard, regular old service, and it's designed to favor the marital trust, if you're a permanent resident couple, you're doing the wrong thing potentially. Also, you may need a built-in, it's called a qualified domestic trust that's part of your trust. And if any of this is kind of scaring anybody saying, oh, this seems really complicated and really expensive. The funny thing is it's not. It's all built into the regular basic trust. You just need a lawyer who knows how to do it. Then it's all built in and you don't have to do anything. It's automatic. So that's the funny thing. And the sad thing with a lot of this is that a lot of people, I used to practice litigation for a long time. If you did something wrong, you knew within about 14 to 21 days when the other side filed the response. And it problems got real quick. That's the problem with some estate planning. This problem's not going to be caught until maybe something bad's happened. So you're not going to be able to know. So that's why you have to do a quality job in the beginning, because the problem can lie dormant and latent and you won't know for a while. So let's move on.
That's very true. We saw that all the time when clients brought a trust to us, and then they realize that's not exactly the plan they want. But that's too late, because usually a client wouldn't find it until something happened. I just want to add one more thing here. In California, we are also a community property state. Community property state, which means husband and wife. In very easy way for you to understand, it means you get half of your assets, your property after marriage, especially for properties you receive from your salary, your labor, income from your after marriage labor. So I frequently encounter this kind of a problem. Sometimes husband and wife, they do not get along. And then they come to me and they said, okay, I do not want to establish a trust with my husband or with my wife. I want to establish my own estate planning. You can certainly do that, but if the other person is not willing to sign something like, they agree, you just need to be very, very careful because, the reality is California is a community property state. And whenever you try to distribute part or some of your properties, which is community property, you just need to be very, very careful. You need to plan it really well. Okay, so this is the estate planning pyramid we designed for our clients. So as you can see, there's level 1 planning to level 5. And majority of people probably only need level 1, which we just discussed. It's just a basic revocable living trust with power of attorney, advanced healthcare directive, and some guardians consideration, trustees consideration, etc. And then you move on to level 2, which last year we actually did a lot, because many companies last year, some very unique have some very unique opportunities. Their companies went public and suddenly they become very wealthy. So they need to think about their annual gifting strategy. And some people, if they have extra cash, they want to purchase a large life insurance trust. It can be $5 million, $10 million, or $15 million. The largest I ever seen is like $20 million. And then if you are going to purchase a large life insurance, before you do that, usually you need to set up a life insurance trust. This trust is irrevocable, and you use your annual gifting exemption, and then you design the trust, and it can be a dynasty trust, which means not only your children, but your grandchildren, generations after generations can benefit from this trust. We actually did a seminar just talk about life insurance trust last year, and if you are curious about it, if you wanted to buy a large life insurance, you should consider that. And especially, I think for life insurance, I think if you are younger, the rate is much better. So if you can afford it, I highly recommend clients to think about using life insurance as part of their estate planning strategy. Some clients even use life insurance to pay their estate tax because they know their estate is very large. Even with like level 3, level 4, and level 5 planning, they are still exposed to large estate taxes. So they do not want to use their own money to pay the estate taxes. So instead, they purchase a life insurance and use the life insurance proceeds to pay for their estate tax. So that's a strategy too. And Michael, you can just briefly introduce level 3 to 5.
Yes, just want to jump in for a couple of things about the life insurance trust, why we're talking about it. Just a couple basic rules. The estate tax, what is the estate? The estate is everything. And I always kind of have this mantra. They say, what does the estate include? Does it include my houses? It includes everything. Does it include my 401k? It includes everything. The Picasso, everything. Cars, everything. What about my life insurance? But that pays after I'm dead. Everything. And the life insurance, it includes the death benefit value. So if my death benefit value of the life insurance is 2 million, I say, well, I didn't have 2 million during my lifetime. We ask, did you own the policy? Yeah, plus 2 million. This is where people very quickly, when they're doing the pencil calculation of house, 401k, life insurance, they realize, well, wait, whoa, I'm kind of better off than I thought, or worse off under the estate tax. This is where you have to start to think, can I start taking things out of this box, put them into a new box? Life insurance trust is a new box. One thing, this annual gifting, this number is a little bit old that we have here. This year it's 16,000. So married couple is 32,000 per year. You can gift tax free. It doesn't harm your exemptions at all. So very easy there. So that's the level 2 planning. Level 3, 4 planning often goes together. This is really critical if you are the owner of a closely held company. There are techniques as the closely held company becomes more and more valuable that you can contain and box up the value and try to freeze the value and allow the growth of the company to fall into various irrevocable trusts, GRATs, grantor retained annuity trusts, or IDGITs, intentionally defective grantor trusts, basically to try to get this increase in value away from you, where it may be taxed, into next generations to defer the tax over time and spread it amongst the family dynasty. Classic planning and very, very common in Silicon Valley, as you will, if you read sort of the articles, the founders of everything, DoorDash, Zoom, Facebook, all of these things, everybody does this kind of planning. And then the last level is charitable planning, the charitable remainder trust or the charitable lead trust, which we'll talk about just last bit of the seminar. Charitable remainder trust, basically, if I have something that has a whole bunch of capital gains, I have two options. I can drop sell it and I absorb all the capital gains tax right now, or I can do potentially charitable remainder trust. I can convert it into a stream of income and defer the tax and spread it out over my lifetime or potentially 20 years. I can also get a charitable tax deduction. It's pretty nice. And I can convert that stock or rental house that I don't want anymore into a stream of income. Converse, if my company gets merged out and I get a check, a large check, I think, I have a lot of ordinary income in year one. I can flip and I can do a charitable lead trust to try to generate a charitable deduction. So again, both of these things, if I am seeing a tax problem here, there can be a problem with that in terms of generating a lot of tax attributes, but there are solutions: CRT, capital gains, charitable lead, ordinary income. So something to think about.
Yes, I just want to go back to this level 4 planning. So since COVID, we actually did more GRATs and IDGITs than before, because as I mentioned, and Michael mentioned, some companies, they went public because of this unique situation. And then a lot of people, their stocks, the stocks they hold become much more valuable. But do not come to see us or come to us for a consultation after the stock already appreciated.
Yes.
Yes, we see that.
Or you've already sold it. That's a big
Yes.
problem. People sell it and then they say, I talked to the accountant and I have an eye-poppingly huge number I have to pay to the IRS. What do I do? Say, can you devise a time machine and go back and not do that? Because once you have the cash, there's nothing I can do.
Yes. So usually, we work with a lot of companies who is prepared to go public before the company goes to public. And actually, the company has their own corporate attorney to plan for the company. But then you yourself, as a key person of the company, you need to do your own estate planning. You need to do your own estate tax planning. And when the stocks are not so valuable, there are a lot of things we can do. We can set up the irrevocable trust. We can either transfer or sell your shares into this irrevocable trust structures. And then we can design the provisions in the trust. And there are just a lot more things we can do and we can discuss with you. But then once, as Michael said, if you already, if the stock value already appreciated or you already sold your stocks, then there are very, very limited strategies we can use, we can recommend. Okay. I think we are all set here. Michael, do you have any last words for the seminar?
Just some parting thoughts before we move on to the questions. We've got some interesting questions here. I think this is the thing that is always important for me as a estate planner is really what we're trying to do is we're trying to prevent problems and make this be something that you don't have to really do anything about. Just like, again, I don't expect anything to happen to myself when I drive the car, but I certainly do put my seatbelt on. And I did buy a car that was reasonably safe. I think that's the thing. We want to make sure that this is not problematic, that this is something that one doesn't have to think about, and one is safe. And it requires a little bit of time and a little bit of work to put it together. But the key thing that I would urge all potential clients of legal services is legal services are very similar to medical services. You want quality. Years and years and years ago, I'll disclose some secret things about me. I had to have a pacemaker and heart valve put in. I'm going to tell you the first thing that I didn't ask them was, what's the cheapest heart valve and pacemaker you can get? I don't want the cheapest heart valve. I want the best heart valve. I want the one that does actually what I need it to do. And I think that's the same thing for this planning, guardianship, care of the children, the proper arrangement and distribution for tax efficiency, and of course, distribution efficiency of my assets. I want a quality plan. And you will be surprised that quality planning is not very expensive. And I think that's the thing. People sometimes design and they say, well, it's just paper, it's just a form, I can just fill out the form. And I always think about this, because we do a lot of tax work, is if, let's say, Dong Lei, Xiaowei, Mr. Joe, Kathy, we all work at all different companies. And we each earn $100,000 W-2, and we each have a house. We have all these things. When we do our Form 1040s and we put that info into the tax software, we should probably pay all about the same amount because the numbers were all the same. We earned the same amount. We took the same deduction. Shouldn't that tax return be deductible? But I will bet you, Kathy, Mr. Joe, Dong Lei, Xiaowei, none of us are going to have an estate plan that looks identical. When we put that data into the software, if we put it through the lawyer, we put it through the system, we are going to end up with differences because unlike the dry numbers of what we earned for taxes, our families, our children, our assets are not the same. And this is something that has to be tailored and customized to the person, unlike something like a TurboTax where we could just say, oh yes, 100,000 W-2, you got a 1099 INT, okay, we add that in. Then you got a 1098 mortgage interest deduction, we subtract that. Oh, actually that's lower than the standard deduction, so we'll just give you the standard, there's a number. That should always be the same. But we can't really say that I can say, oh, okay, John, you have 2 children, you have a wife. I assume you and your wife get along. The children, yeah, they're probably fine. How about to the wife and then to the kids? Yeah, let's do that. Maybe I'm right. Maybe I'm massively, massively wrong. So that's the thing that's a little bit different with this. You have different variable inputs and we have to work it out. And we love to do it. I'm happy to say I love my job. I love working through this with all of you. We have fun doing it and it solves problems. So that's the thing. Fun with doing the practice in this area. We get to solve problems.
That's very true. Yes. Hopefully everyone enjoys our presentation today. And if you have any questions, feel free to send us an email or call us, or you can add us on WeChat. Feel free to give us a call, and we can offer a free 15-minute consultation. And the consultation, we want to understand your family dynamics, your family situation, and then we can go from there. Okay.
I see some questions. Should we go into that, or should we?
Yes, please feel free. Yeah, we have a lot of questions. Yeah, in the chat box.
Outstanding. Yes, I'll take a look at a couple. So actually, a good question that we have is the probate fees. Where did the probate fees come from? 2 situations where this can come from. One is the person's a California resident and you're administering the estate in California. That's one direction the fees can come from. That's an obvious one. But it can also come from owning California property and not doing planning in your home state that's coordinated. So California, it's called ancillary probate. If I live in Delaware, let's say Delaware, a state that you don't normally do trusts, I do the thing in Delaware and I say, Delaware, the commissioner of wills says it's A-okay, and I don't do anything with that California property. I just leave it in my name and I say everything's fine under Delaware. it's going to cause what's called an ancillary probate. And I'm going to have to pay the fees to a California lawyer and do an ancillary probate in California. So it's place of administration and where the property is. So that's the answer to that. Are we in San Francisco Bay Area? Yeah. Behind me, you can't tell the sun, but that's downtown San Jose. So I'm right there. And it's actually not a virtual background. I've actually, that's the window. So we're close. The $12 million right now per person, married couple, 24. When it drops back down, 6 and 6, 12. So that's pretty quick. Here's a complex question. If you have a couple with one child, can you set up the person saying will so that when one spouse passes away, part of the assets are attributed to the child? First thing I'd say, let's not use a will because we're going to have probate and we're going to have a lot of problems with that. But I got a good solution. Let's use a trust. Let's use a trust and let's have a provision that commonly is used as called a Q-tip, qualified terminable interest trust. I go, my half, that's my property, has a light lock. Maybe that light lock says my wife can live in the property, she can take income, but the principal, she can't pull out unless a neutral trustee signs off. Otherwise, it drops down to my children. Very commonly requested. We can do designs like that where we say, I love my spouse, but I just want to be certain, that she doesn't, run off with the pool boy or something like that. I better be extra careful. This has been a concern in the common law for 800 years. This has been, you will see trust 800 years ago. This was the problem. We've been solving it for a long time. So yes, you can absolutely do that, but the ideal vehicle is the trust. Life insurance is excluded for non-resident aliens. Yes, that is usually true. If you were a non-resident and then you became a green card holder and then passed away, would it be part of your estate? Most likely. This is an especially weird thing with permanent residents. Permanent residency does not 100% automatically determine estate tax treatment. The determination of estate tax treatment is actually a concept called domicile, which is your intent to reside somewhere. So if you are a permanent resident, it sounds like your intent is to stay in the US. But there are cases, one is the state of Con, and then the other one's Van Hoven. They reached two opposite conclusions. Poor Mr. Khan, he was Pakistani, he was a green card holder, he became ill, he went to Pakistan for treatment, he got worse, unfortunately, he was stuck in Pakistan, green card went out of status, and then he died in Pakistan. Appeared, the IRS said, oh, he's a foreign person, he's not a US person, no domicile. They sued the IRS, the tax court said, no, the poor man, he was stuck in Pakistan and he was hoping, just pointing towards America and say, someday I'm gonna get back to my home. And they said, he's a US person. No tax due. Van Hoven's the converse. He was stuck in America. Why? Because the Nazis had invaded the Netherlands. He said, oh, as soon as the Nazis get kicked out of there, I'm going back to the Netherlands. He died in America. They said, oh, IRS said, oh, he's American. He's US person. His assets abroad should be taxed in the US. Tax court says, nope. But for the Nazis, he would have been Dutch. We have these weird cases. And the taxpayer wins both, that's good, but the rule is opposite and it's not reconciled. So the short answer to this question is likely it's part of his estate, but I can't give a firm answer because it's much more complex than that. Very similar question is someone who was a green card holder when they purchased the insurance and then they surrendered the green card. Likely the insurance is now out of the estate. The person's now a non-resident alien. My belief on this is that the person's also not, we call it a covered expatriate. You have to be very careful if you lose your status that you were not a covered expatriate. Likely in both of these cases. So in case one, the person who was foreign became US, it's likely US. The person was US and then became foreign, it's likely foreign. That's likely what happens. But again, we'd have to actually take a look.
I just want to add one more point on this. So for large insurance policies, no matter what, no matter the person's the status, we usually would recommend the client to think about life insurance trust, because it's just not a good idea to give the beneficiaries a large fat check at once. And with a trust, you can do so many plannings, and you can, design the trust the way you want. You can, in the trust, you can provide for generations and generations, and you can provide incentive for your children, for your grandchildren. You can even provide a family fund for traveling, for reunion. There are just a lot more things you can do, and more flexibility in a trust.
There's a great question here that is a very complicated one here. For a green card holder, and we have this problem with citizens too, and you own shares in a Chinese company, how do you plan for that? This can be planned around, but it is quite complicated because it generally has to work as a cooperation between lawyers in China, because China, and this is not just a Chinese issue, this is also an issue in France and Germany that are not common law countries that don't use the trust. There has to be a coordination of how do you take these shares from a legal system and where they are considered property and place them into a container in a different legal system using a different conception of property. Common law, which is the English legal system that the US uses, Canada, Australia, New Zealand. I say England, people say UK, wrong, not Scotland. Scotland's a civil law situation. Wales, yes. Northern Ireland, common law. Ireland, a little bit different. So the common law system is you can have property and I can split out. So ownership under the common law system can be, you can divide title, which is the legal title of trustee, and equitable ownership, benefit of the money. Common law, we say, oh, so owning land, we can divide the ownership into many different sort of particular classes of ownership. Common law does that all the time. Civil law does not conceive of property in that way. So can we do planning on this? Yes. It is quite complicated because you generally work on two sides. There is a system where on the Chinese side, it is bundled appropriately, sometimes with holding companies that will hold it, and there's an intermediary. It can be done. So it is workable. Common for green card holders, very common. There are a number of persons who are US citizens who own these Chinese company shares, critical for them because often high value. And this is also critical for foreign persons. If you own property abroad, this is actually final thought and a little bit of a pivot here. You have to plan under the law of where the property is. So if I do fantastic estate planning in the United States, if I own property in Japan, I need to arrange the planning in Japan under the Japanese system that is coordinated with the US plan. It is extremely difficult to take the US system, a US will and a US trust, and bring that to Japan. Why? Civil law country again. They're going to say, we don't even conceive of property this way, let alone what you're trying to do. So trying to merge these two things is oil and water. What you need to do is you do Japanese side, American side, and you do a bridge. That works very well. If you try to take one to the other, does not work well. PRC China is a classic one, does not work well. India is another one, does not work well, because India has common law elements, but especially with regarding Indian real estate, it's one of the world's great cultures. There's thousands of years of history about this land. They're not going to just take something from California and transfer the land. They have a system. You have to work with that system and coordinate it.
I just want to add one more point to this U.S. green card holder or U.S. citizen holder Chinese public company stocks. This issue actually has been presented to us many times, and usually for us, the job is not difficult to design a U.S. trust, a US irrevocable trust. We can design the trust the way client wants. The difficult part, the problem is always on the Chinese side. So you will need to work with a Chinese attorney who is very experienced in helping Chinese officers, Chinese public company officers and the business owners to how to put this stocks into this US irrevocable trust. Actually, now we are working with a large law firm to help our client to achieve this. But what we can see is it's not easy. It's quite difficult compared to if you just want to put your US stocks, your stocks in DoorDash or Zoom into this US irrevocable trust structure. The Chinese one is just much more difficult. And for the international estate planning, for Chinese citizens, for Taiwanese citizens, for people who have assets abroad, not in the US, we usually encourage clients to do their estate planning in the country where their assets are, especially real estate. And China, mainland China and Taiwan, they do not recognize any US estate planning documents. Hong Kong, the High Court actually recognized US will and trust, but we still encourage clients who hold Hong Kong assets to see a Hong Kong attorney to do some local estate planning.
And it's even more complicated. Just a little bit about my background. So I am a licensed attorney in California. I'm also a licensed attorney in DC and a licensed attorney in Wyoming. So again, why Wyoming? People, of course, the love of the beautiful mountains and things like that. It's an excellent trust jurisdiction. So the reason I mention this is another thing that we also have to think through is, does a large estate or a complicated international estate need not just California planning? Do we need structures in another state like Wyoming as a wealth repository? Or this is very common for foreign persons. They say, yeah, I'm a PRC Chinese person. I don't really want to do the planning 100% in China. Maybe we need a third jurisdiction. Maybe we need something like the Cook Islands or something like Cayman or BVI. The Hong Kong lawyers love BVI, so they always send everything to BVI. There are more options than that. But it is something when one's trying to put something together with significant wealth, and what is the most fun of this is putting together the different parts, putting the pieces together, and then it comes together. And just like all of you, with CASPA, all of a sudden it comes together and it functions, it turns on, and it does something. And that's what makes us really happy and is rewarding in our practice.
All right. Do we have more questions? I don't see questions.
I think that's pretty good. It's been an absolute pleasure. Again, you all have our email, our QR code. Please don't be a stranger. We love to hear from you, and we look forward to meeting you personally and perhaps maybe in person as COVID goes away, we hope. And I wish you all the best of health and have a prosperous new year. It is a year of the tiger, right? So
yes.
Do enjoy.
Yeah, so because of COVID, we actually do not accept the office visits anymore, except for when clients come to our office to sign and execute the documents. But we are always happy to schedule a Zoom video conference with our clients or potential clients. And as Michael said, we are happy to answer your questions. Feel free to send us an email, and we can schedule a Zoom consultation with you. Usually we are very busy, so we probably won't schedule the consultation in a week, but we're always very happy to help you.
All right, then thank you, real attorney Michael, and shall we again? And then if you guys have no more questions, I think our seminar will end it now then. All right. Thank you.